Hello, everybody. Hello. Welcome to our special sub chat Sunday. Good evening. Hello. Hello, good to see you. Hello, everybody. This is our sub chat only tonight. So it's a special thank you to all of my subscribers, as well as to give my moderators a break. So welcome in, everybody. Welcome in. Hello. Good to see you. Yes, hopefully everyone's had a good weekend. Hopefully. I think my weekend's just been too short. It was good, but too short. I needed another day, I think. Another day would have been all right. But you can't always get that. So yes, hopefully everybody had a lovely weekend. Oh my gosh, thanks, John. Thank you so much. Yes, well, welcome in, everybody, to my sub chat Sundays. So this is where I turn on comments for my subscribers. Need a nail sponsor. True story. True. Oh my goodness. Yes, I agree. Hello, Suze. Hello, Kristen. Good to see you. Yes, we need longer weekends. I agree, everybody. We need a longer weekend. Yes, I vote for one more day. We need 3 days for sure. I would vote for that. Put it on a referendum. I'm going to vote for it. Oh, for sure. Well, welcome in, everybody. This is my special subscriber chat only Sundays. And tonight, everybody, we've got a fun thing that I'm going to try to do. We have dueling motions tonight out of the Florida case. So we have the Mr. Trump's motion to compel discovery out of Florida. And then we have the government's response, which was none too happy about it. When I scrolled, oh yes, the lollipops had to come out earlier. We had some trouble earlier. It's all right though. We got it taken care of. We'll be all right. Yes. So this should be really interesting, everybody. Rather than reading through the entire motions, I'm going to read a chunk of Mr. Trump's motion and then the response from the government. So we'll go back and forth. It's a little spicy, everybody. It's a little spicy, just a little bit. So should be pretty fun. Fun for me. I'm not sure if it's fun for them or not, but 4.5 days, 1 week and 4 days. Nice. Well, that's nice, but I bet those are pretty intense days, though. I bet. I've always noticed that whenever anyone gets that third day off, then the days you are working are pretty intense for sure. So it's a lot. Yeah, it's a lot. But yeah, I could use an extra day this weekend. I don't know what's happened, but I am just so tired this weekend. Too much going on, I think. Too much going on in the world. So we could all use a little bit of a break. For sure. Oh, he's an engineer. Okay, well, yeah, hopefully he's taken enough of a break for himself then when he's working so hard. I have a dear friend who is a chemical engineer, and I always wonder how she gets everything done. What was the outcome of the pre-dinner party? It turned out okay, everybody. Oh my goodness, I tell you, I just don't get it. I mean, it seems like there's basic things like setting the table and making sure that there's enough water glasses. But meanwhile, the aquarium's getting cleaned out and the basement's getting rearranged. And I don't understand. I don't know. I don't get it. I don't know why the brain works that way. Oh my gosh, it cracks me up. It absolutely cracks me up. I've been off since Thursday. Oh, okay. Well, that's all right. Yes, and howdy to you too. Welcome. Some attorneys are saying Trump is getting the benefits of judges slow-walked. Perhaps. I'm still not sure yet. Not sure. Anxiety coping mechanism. Perhaps. I'm not sure. I think, I've shared this before that he has a book coming out and he just got his first copies So I think he's got kind of he's got a little extra energy about him. So maybe he's just trying to check things off of his list before things get crazy. Perhaps, perhaps. So, yes, I agree. I agree. May sweep the garage or the basement, and then the tank may have been dirty. True, sure, sure. Okie dokie. Yes, jitters. I think that's the right word, Suze. Yes, I think so. He's got some jitters. Yes, but he'd never admit to it, so that's fine. Whatever. He's just a nutball. That's fine. Well, that's fine. I know, VC. I know. I just looked at him like, what? But what are we doing with the aquarium? But what's that all about? I don't understand what you're doing. Yeah, he's fine. He's fine. He'll, shake it off, rub some dirt on it. It'll be fine. He'll get through it. Give him a list. Yeah, it's nervous cleaning. I think so. And you know what? At least he's doing something. So I'm thankful for that, even if it is, cleaning the aquarium before our guests are due over. Whatever. It's something. It's something. So there's that. I don't know why I feel like each time it's a surprise to me, even though it happens every single time. So I don't know. And meanwhile, he's like, why are you vacuuming everything? I'm like, what do you mean, why am I vacuuming? Oh, my goodness gracious. Yes, but yes, it was a lovely dinner. Everyone had a great time. And now we have a clean aquarium. And there's some small space in the basement that has been reorganized. And so I'm really looking forward to that. Oh my gosh. I know. I just don't, I don't know. I don't understand how his brain works in a lot of ways. I would like to blame it on just the chromosome differences, but that's just not it. There's more to it than that. There's so many more things I don't understand. So I'm sure the fish appreciate it. Well, Kristen, we have one fish that's been hanging on. We had a full aquarium full of fish and they died. And then we have one fish now that just will not, fulfill his destiny and join his family in the promised land. He just will not. And so it's one fish for this huge aquarium. Oh my gosh, I'm just like, oh my God, please, please. I know the last one hangs on forever, but whatever. It's you have one fish hanging on two. Well, you know what I mean? I think there's just something about it. They're like, I got the tank to myself, so I'm going to stay here forever. Like, all right, fine, whatever. Oh my gosh. Terrorize them into fish heaven. Could be. Oh my gosh, that's so funny. Yes, well, we've got one fish who is still, doing the fish job. So we have this huge aquarium with one fish in it. But whatever. These things take time. We were committed when we first got the aquarium. So we can't rush. We can't rush him. Oh my gosh. Although one of these days he may accidentally hop out of the tank. No, I'm kidding. Oh, that's awful. Oh my gosh. They live for a really long time, Kristen. I know. I just am like, oh my gosh. How long are you going to stay? Oh, anyway. So, yes, the aquarium's nice and clean. And, thanks. We had a lovely dinner. It was quite nice. Yes, we used to do a honey-do list. We used to do that back in the old days, but, then I was like, whatever, I don't care anymore. You reach a point where you recognize you're going to do it yourself or it's not going to get done. So we've reached that point, and I'm okay with that. We recognize that, both of us. He knows that too. If there's something he wants me to do, it's not going to get done. So he needs to do it himself. Oh my gosh. Yes, but we have a mutual agreement. We both understand that that's how that works. So there's a walking catfish. Really? Oh my gosh, that's a stitch. Yes, I might need to look into that. Maybe give you the Pied Piper and walk the other fish out. Oh my goodness gracious. Well, welcome in everybody. Welcome to our Sub Chat Sundays. I do like to have my subscriber only chat function open on Sundays as a huge thank you to my subscribers. Thank you very much, everybody. I have just put in my new toner and I'm very excited about it. And I took your advice and had paper delivered this time, so I didn't have to get assistance getting the paper. That was huge for me. That was, wow, that was enormous. So thank you for the toner fun, everybody. I'm very, very thankful for that. So we're back at it, everybody, tonight. Now, I had a couple of things that we could go through. This is going to be a very exciting week because, of course, at the end of the week, we've got Supreme Court arguments. So I am hoping to kind of go through some amicus briefs throughout this week and kind of get us all ready to go for the arguments. That should be very exciting. But also, there is one thing that I found very interesting in the Florida case. Now, we haven't really talked about the Florida case very much. I did a brief kind of pop-up live or bonus live on Saturday walking through the docket. But in Florida, the most recent filing by the government is a response in opposition to the defendant's motion to compel discovery. So when I was going through this, the government's kind of getting a little frustrated, I think, with Mr. Trump, and rightfully so. Mr. Trump had filed this motion to compel discovery, and he had filed it on the 16th of January. And there's a lot in here. There are a lot of accusations in here and a lot of things that are, not good. So I thought we could take a look a couple of ways, and I'll take you through just the table of contents for this first motion filed by Mr. Trump, and I'll take you through the table of contents, and then I'll take you through the table of contents for the government's motion. So we'll kind of do a back and forth here, because the biggest piece of Mr. Trump's motion that I found very interesting was this evidence of bias and investigative misconduct. So he's claiming the special counsel had coordinated with the Biden administration and the Georgia prosecutors, and that there's an intelligence community bias and a NARA bias. So he is setting out kind of all of these accusations, saying that everything is all biased and everything is all against him. So I will kind of read through this. This is not too many pages. And then the government comes back in and says, you're full of bologna sandwiches. This isn't true at all. And so we can go through each one of theirs. So I thought that would be an interesting way to kind of update us on where we're at in Florida, because again, this was just filed by the government on the 2nd. So why would Georgia talk to DC and Florida? I know. It's a lot. He's laying it on pretty thick. And the government is so frustrated, even with the very first sentence that they have here. So they're talking about how the defendants have gotten all of this discovery, and the government's provided 1.28 million pages of unclassified discovery. And so they have to come in here and clean up the record with their brief, essentially, because of this filing that they did. I don't think he does sort it out, Steffi. I'm not sure that it is sorted in his brain. I'm not quite sure how all of this is playing out. But let me put this in a frame, and I'll go ahead and put a sticky note. So again, I'll just do an overview of this brief and then start going through the specific parts that we can match up then with the government's brief. So this case is U.S. v. Trump, and this is the Florida case. So we're in the Florida documents case. Florida documents, and I will go through Trump's motion here for discovery. Now remember, in the DC case, he is saying he doesn't want any discovery, but apparently in the Florida case, he's all about that. So Trump's motion to compel discovery is what I'll go through first here, and then we'll go through the governments. Now I will try to remain as friendly as possible, but you know, as Mr. Trump's motions tend to do, they tend to get a little out of hand as you get further through it. So we'll hopefully see. Yes, I have my butterfly pen tonight, everybody. Hopefully. Oh, it's got a little shimmer to it. We need a little sunshine right about now. So this is all, again, available online, everyone. If you are interested in pulling this case yourself, this is the case number here. So you would just put that into your search engine. The document I will be going through is document 262, and it was filed January 16th. So this is Mr. Trump's motion, again, to compel discovery, which is really ridiculous. All right, so I shouldn't say it's ridiculous. I feel as though this motion didn't necessarily need to be filed. How about that? That's better. That's better than saying it's ridiculous. Be Switzerland, yes. Suze, I will certainly try. Switzerland. Okay. So let me take you through a summary here. Oh my gosh. All right, so we have the introduction that he sets out in the background. Now, I will be reading through that introduction. It's pretty short, and I think it gives us a good overview of where he's coming from. And then his background, he goes into pre-indictment investigative activities. So this is things going on before he was even indicted. So we had early indications of NARA bias. So this is the National Archives. That is the branch of the government that keeps track of all of the presidential stuff. So any speeches, any papers, all of that stuff is has to be registered with the National Archives. So they're involved here. I know, Suze, right? I'm sure it makes sense to somebody. Yeah, good question. Yikes. So he's saying that the National Archives is already biased before he was even indicted. So we'll talk about that. The Biden administration weaponizes the PRA, and that's the Presidential Records Act. So they're somehow weaponizing that act. I don't know. All right. See, the transfer of the 15 boxes to NARA. The White House instructs NARA to contact prosecutors, which I don't believe is true. NARA's sham referral, again, this is all Mr. Trump's filing, and the Department of Justice claims of urgency relating to damage assessments. So again, I'm just doing an overview of his motion to compel discovery. And then we have the procedural history, which is set out. So, yeah, he thinks Biden got treated differently. I know, everybody, I know. All right, so here's our discussion piece. Again, just the overview. I will be focusing on one piece of this later on. So number one, the court should reject the prosecution's narrow definition of the prosecution team. All right, so he's asking for a broadened term of prosecution so he can get more records for more and different departments. Yes, they're librarians. I think that's an excellent way of putting it. All right, here's the applicable law. So prosecution team scope under Brady. Brady is a case that said all exculpatory evidence has to be given to the defendant. So that's what the Brady rule is, or the Brady case. Here we have control under Rule 16, which goes hand in hand with Brady, and then case file reviews. B, the prosecution team includes agencies and attorneys that participated in the investigation. So instead of it just being Jack's team that's going forward, he's trying again to really widen the team out. So here's who he thinks should be included as the prosecutors in his case. So number one, we have NARA. Again, that's the National Archives. 2, the intelligence community. 3, the White House. So the White House is prosecutors. Oh my goodness. 4, the Department of Justice. 5, the Special Counsel's Office. Now that's where the special prosecutor's out of, so that makes sense. 6, the FBI headquarters, the Counterintelligence Division. 7, the Secret Service. Oh my goodness. All right. And next we have C, the Special Counsel's Office has had an affirmative duty to search for discoverable evidence. So one of the big arguments that the government has is like, hey, we can only give you the evidence that we have. If we don't have evidence, we can't give it to you because, we don't have it. And so what he's saying is that, well, you should have been going out and looking for it. Oh my goodness. So there's that. So that's a piece there. I think that's a very interesting take on prosecutions. You should be looking for more evidence, find more. And then we have 2, the Special Counsel's Office must be compelled to comply with their discovery obligations. Applicable law, favorable evidence under Brady, material evidence under Rule 16, improper coordination with NARA to abuse the grand jury process. So now he's claiming that the grand jury process that was used to indict him was abused. Isn't there enough evidence? I know, it's a good question. Was this brief filed before we knew about the hidden room? Well, I don't know exactly when everybody knew about the hidden room, but as far as the public goes, we'll say that was just within the last few days. So yes, this was filed before the public knew about this hidden room. Didn't they already comply? Yes, they did. Yes, they did. And we'll read about that. So we'll have our dueling motions going here. Oh my goodness. All right. So again, we're claiming the grand jury process was abused by the National Archives. And they set out the background for that. And discussion. And then next we have the attempt to retroactively terminate President Trump's security clearance and related disclosures. So of course we have this question of, once you're not president, your security clearance isn't the same as if you were president. So there's that. We have a background in the discussion. Next, use of secure facilities at President Trump's residences. So he had to have secure places when he was president in order to look through certain documents and stuff. So there is some discussion of that. And then E, which is what I will be reading through here. Evidence of bias in investigative misconduct. So first, he's talking about the special counsel coordination with the Biden administration, the Biden administration coordination with Georgia prosecutors, intelligence community bias, NARA bias and improper coordination, other prosecution team bias, and production of correspondence and or communications concerning counsel. He wants the documents on the public record. Yeah, there's a lot of that going around. And then F, production of all correspondence and or communications concerning the search of Mar-a-Lago. So he wants all information, even if it's information that the prosecution doesn't have. And then production of the CCTV video footage. So that's his motion, everybody. All right. So again, because we're kind of doing dueling motions here, that's his intro. So let me show you then, and I'll just update this. So we'll kind of go back and forth because we have the government's response. And I think it's best to kind of do them at the same time. So let's look at what our table of contents is for the government here. Let me get this back in order. There we go. Okay. I know. It's a lot. Oh my gosh. All right. So this was filed again on February 2nd, and there was a lot of other filings that happened in between. But here is the opening to the response by the government to his motion to compel discoveries. Let's take a look at their introduction here. So they have an introduction and a background and an argument. First, they have applicable law. So defendants seeking to compel discovery must show that the evidence they seek is material to their defense. That's an important piece. Number 1, a showing of materiality requires a specific request for an item accompanied by an explanation of how that item will be helpful to the defense at trial. Number 2, requests for information pertaining to an allegation of selective prosecution or political bias do not satisfy the materiality requirements of Rule 16 or Brady. So they're saying, these questions that you have of bias, those aren't even relevant to this argument. And B, defendants are not entitled to discovery of items that are not within the government's possession, custody, or control. And this is the big thing, is they're saying, hey, we don't even have any of this stuff that you're talking about. So why would we need to give it to you if we don't even have it? And then C, defendants are not entitled to discovery of internal government correspondence and memorandum or to documents that are otherwise privileged, which makes sense. Number 2, which I will read through again in more detail, but we have A, the court should deny defendant's request for evidence of improper coordination with NARA and of bias in investigative misconduct. Number 1, these selective prosecution claims are not material to the defense for purposes of Rule 16 and Brady. Again, that means to give discovery to the other side. 2, some of these requests seek evidence that does not exist. Now, that's kind of a problem. Or is not within the government's possession, custody, or control. So we're back in this situation, everybody. Do we remember our subpoenas that were being requested, where Mr. Trump had put subpoenas out, Ducey's take-home subpoenas, and asking for all these records from the January 6th committee that he claimed were destroyed? And the government was saying, oh my gosh, that doesn't exist. What are you talking about? Remember that? We're kind of going down that same road again, where he's requesting information that doesn't exist. And so there's no way to give this information to him if it doesn't exist. So that's that argument that continues to go there. So here are some examples. Communications between the prosecution team and members, relatives, or associates of the Biden administration. NARA, again, that's the National Archives, the White House, the intelligence community. So still kind of going off of how they wrote their motion out. And then 3, the defendant's request for internal communications by members of the prosecution team seeks items not subject to disclosure. So they're asking again for information that's not subject according to their motion. Is Trump thinking up this stuff, or is it advisors? That's a great question, Cynthia. I really don't know. So, at this point, I just don't believe that Mr. Trump is the brightest bulb on the Christmas tree. And so for me, I can't believe that he would have the wherewithal to kind of think these things up. But I think he has people around him that can come up with these interesting, ways of manipulating the legal system and asking these questions. So I don't think it's necessarily him, and I'm not sure that it's really his attorneys. I think he's got people around him that are kind of buzzing in his ears. Well, let's, try this. Let's try this weird thing that's, people don't do before. And, so I think he's got people around him, probably like the Penguin, probably like the other people that he's given, various highlights to, are whispering in his ear and saying, well, hey, let's try this, let's try that. And so then he's asking his attorneys to do it. Yeah. Could be his kids. Oh, could be. Could be. Well, I mean, let me go back. Could be Ivanka and Jared. Could be. It's possible. Yeah, the others. The others. You can ask them, okay. I'm not asking any questions. I don't know. Yeah, I think there are literally people around him, standing next to him, whispering in his ear. And if Clark and Eastman are any idea of how you can kind of tangle up and twist the legal system up, if they're good examples of that, yeah, he's got people around him doing that. Rudy sub emoji. Oh my gosh, yeah. Although I don't know about Rudy at this point. Rudy is probably tired. And that's how his attorneys eventually end up pleading guilty to crimes. Yes, Ivanka's out and helping some of the. Yeah, well, I mean, Ivanka is, the catalyst to get to Jared is my thought process on it. But yeah, I'm just guessing. These are just my thoughts on it. But yeah, I think that's a valid question. I think he has people around him who have sat around contemplating how to twist and manipulate the legal system. And they're trying to put those into effect now. And we're all having to deal with their, bologna sandwiches. Can't Trump get the evidence directly if the government doesn't have it? Of course he can. Of course he can. Yeah, he can go after the evidence. But his whole shtick here is that this is a big conspiracy. And so, like they're all keeping a whole bunch of this evidence like underground, and the Masons and the flat earthers are hanging out with the Easter bunny, and they're all like holding this evidence against him and putting it on signs and dancing around a fire or something. So his whole thing is that this is some big, huge conspiracy. And so therefore he's trying to say, well, then you should give me all the stuff that you all have, that we all know you have, that you're hiding from me. So I wish it was going in front of Judge Judy. Me too. Me too. I would be a huge supporter of that. But yeah, that's what he's trying to do. I knew the Easter Bunny was up to no good. Well, you know what I'm saying though, right? It's all part of a big shtick thing. All right. B, the court should deny defendant's request for evidence related to Trump's security clearance with the Department of Energy. That's incredibly specific, everybody. Well, that's specific. The court should deny defendants' request for evidence related to secure facilities at President Trump's residences. And I don't know. I don't know that this is really, I don't see the harm in it. I think, his defense is going to be, well, it's not, it was secure in certain places because, I was allowed when I was president to see those kinds of documents. I don't see how that evidence would be harmful. But what I can see is that it would be cumbersome to a jury. It would get the jury confused. Like, certain spots were okay, but certain spots were not okay. And all of the documents now were in the not okay place, but before they were in the okay place. I could see how that would really tangle things up for the jury. The court should deny defendants' request for production of materials concerning the search of Mar-a-Lago. All right. The court should deny defendants' request for production of CCTV footage. I can see that. I do not think a bathroom is in one of those locations. Yeah, I agree. I'm not sure the ballroom was zoned for nuclear codes. Defendants' request for unredacted discovery of materials should be denied. And, yeah, I mean, we can't really trust them with unredacted stuff, everybody. Here, we've got some questions. Defendants Nada and De Oliveira's request for disclosure of non-classified discovery should be denied as moot. And so I'm guessing they're going to say, we already gave you all of the information. So that's the government's argument, all right? So let's go back to Mr. Trump's motion. Here, I'm going to try to make sure I stay within heavy indictment with the list of various classifications. Yes, thank you, VC. Appreciate that. Yes, we've got our 3 levels of classifications that are set out by law. So let me read the introduction to Mr. Trump's motion, and then I will read the opposite from the government, all right? So we'll just kind of flip back and forth here. On hand right beside me. Okay, wonderful, excellent. All right, so here's the introduction. All right, so the best way to keep in mind which motion, if we get turned around a little bit, everyone, is to look at the date. The January motion is Mr. Trump's, the February is the government's. All right, here we go. Introduction. President Donald J. Trump. So you know that this is filed by Mr. Trump. Respectfully submits this memorandum and the accompanying classified supplement in support of defendants' motion for an order regarding the scope of the prosecution team and to compel the special counsel's office to produce certain discoverable materials. And then we have footnote number 1 here. Pursuant to the court's January 12th of 2024 order, defendants Trump, Nada, and De Oliveira are submitting a single consolidated unclassified brief in support of these motions. The combined number of pages in this unclassified brief and the classified supplement are well below the page counts allotted by the court for this purpose. Yeah, there's 68 pages. The special counsel's office has disregarded basic discovery obligations and DOJ policies in an effort to support the Biden administration's egregious efforts to weaponize the criminal justice system in pursuit of an objective that President Biden cannot achieve on the campaign trail, slowing down President Trump's leading campaign in the 2024 presidential election. My goodness, that's a lot. We're laying it on thick, everybody. The patent absurdity of the office's efforts is illustrated by the fact that while working towards a historic landslide victory in the Iowa caucuses yesterday, President Trump was also preparing to bring your honor's attention today the record of misrepresentations and discovery violations that have marred this case from the outset and illustrate that the office has disregarded fundamental fairness and its legal obligations in favor of partisan election interference. Just so you all know, this whole paragraph is 2 sentences. I'm just going to put that out there, okay? This is 2 sentences. Are they serious? They are. I know. Already campaigning from the first paragraph. I know. It's going to be more than a minute. I agree. New evidence. Ooh, that's exciting. New evidence obtained via request pursuant to the Freedom of Information Act, or FOIA, reveals that politically motivated operatives in the Biden administration, that's the Easter Bunny, everybody. He discovered the Easter Bunny. Oh my goodness. The Easter Bunny in the Biden administration and the National Archives and Records Administration, NARA, began this crusade against President Trump in 2021. There are 22 FOIA releases from the DOJ and NARA attached as exhibits to this brief. Nearly all of these exhibits, though heavily redacted based on FOIA rules that have no application in a criminal case, represent discovery violations in which the special counsel's office, oh my goodness, failed to produce documents that support arguments and positions the defense has articulated since at least October of 2023. That wascally rapid. Oh my goodness gracious. Oh my gosh, everybody. It gets better. The FOIA releases, coupled with other evidence scattered throughout more than 1.2 million pages of discovery, reflect, which is not enough, everybody, reflect close participation in the investigation by NARA and the Biden administration components, such as the White House counsel's office, as well as senior officials at DOJ and FBI. These revelations are disturbing but not surprising. The Biden administration leaked to the New York Times in April of 2022 President Biden's view that President Trump, quote, should be prosecuted, end quote. The Attorney General then proudly announced in August of 2022 that he took the extraordinary step of, quote, personally, end quote, approving the raid at Mar-a-Lago. My goodness gracious. Oh, the rabbits. The rabbits are on the loose. However, the details reflected in the FOIA releases add force to President Trump's long-held position regarding the scope of the prosecution team. Thus, these materials should have been disclosed by the office in unredacted form at the outset of the case. The parties' dispute regarding the scope of the prosecution team also extends to the intelligence community and the National Security Council. In this regard, the special counsel's office would have the court believe that the prosecutors have only dealt with these agencies at arm's length. Evidence relating to extensive coordination during the classification review process puts the lie to these claims. Equally telling, in submissions to Your Honor in August and September of 2022, DOJ asserted in Trump v. U.S., which is never good that you should be citing your own cases. Oh dear. Whoopsies. That the intelligence community was closely interconnected with and cannot readily be separated from the investigation. Can these attorneys be punished for these outlandish briefs? I hope so. I certainly hope so. They would know about lying. Oh dear. Oh my gosh. Again, the office's position is disturbing but not surprising. The prosecutors cannot escape those representations here. These issues are central to the instant motion because the special counsel's office is seeking to avert its eyes from exculpatory, discoverable evidence in the hands of the senior officials. Oh no, not that. Anything but that. Oh my gosh. At the White House, DOJ and FBI, who provided guidance and assistance as this lawless mission proceeded, and the agencies that supported the flawed investigation from its inception, such as NARA, the Office of the Director of National Intelligence, ODNI, and other politically charged components of the intelligence community. As discussed below, even the Department of Energy has taken up the Biden administration's mantle by seeking in June of 2023 to terminate President Trump's active security clearance, which is a highly inconvenient fact relative to the office's allegation of unauthorized access to classified information under 18 U.S.C. Section 739 sub E, and modifying and amending agency records that support President Trump's defense. Can he and his attorney be charged for waste of court time? Well, there's ethical questions. There are huge ethical questions anytime I read any of his filings these days, for sure. I am putting together a live to go through some of the filings and break apart like Rule 11 and several of the other questions that we have. But that usually happens after the case has finished, so as opposed to in the middle of it. Thank you, Kristen. It should have been terminated long before then. You know, that's a valid question. That's a good question. When should that security clearance from the Department of Energy have been terminated? No defendant is required to predict every form of exculpatory discoverable evidence that exists. It is incumbent upon the special counsel's office to collect and produce such materials based on a fair, judicially enforced definition of the prosecution team. So this is where he's saying that the special counsel's office has to go and do a full investigation for him. However, to be clear, the record discussed below strongly supports the existence of additional evidence of bias and political animus that is central to the defense of this case and must be produced promptly. Again, I would remind you, the government's already filed a motion saying we don't have any of that stuff. This includes evidence of collusion between the office and the White House, DOJ, FBI, and NARA to use the Presidential Records Act as a law enforcement tool. That doesn't even make sense. I thought he said he was using the Presidential Records Act. Wait a minute. I'm confused. He was not actually qualified to hold one. True. Wait, didn't he say he had authority underneath the Presidential Records Act to do whatever he wanted to do? But now he's saying they're using it incorrectly. Oh my gosh, I'm confused. And to abuse grand jury procedures. Wow. Whoa. In violation of due process, other constitutional rights, and the executive privilege. He did repeatedly. Yeah, I thought we went through the Presidential Records Act, and I remember saying, this is interesting and has nothing to do with anything involving him. Okay. The office must produce other evidence of bias. Well, like if they actually have it, including one, any communications with members, relatives, or associates of the Biden administration. So if there was any communication with a relative or associate of the Biden administration, they have to turn over that communication. How does that work? I just threw out everything there, including the kitchen sink. All right, that's what the relatives or so. Oh, come on. Number 2, communications between members of the Biden administration and the Fulton County District Attorney's Office during the course of the investigation that led to this case, including but not limited to records relating to meetings involving Nathan Wade that are substantiated by legal invoices appended to congressional filings. What? What is this? Why would the president be involved in a state prosecution? This is crazy. It's all spaghetti. When does he have to provide evidence of all this baloney? Great question. All right. Well, again, I will go straight into the government's response after this, but this is a lot, everybody. All right. And 3, evidence relating to analytic bias harbored by the intelligence community that President Trump will use to impeach positions that are relevant to 793E's requirement relating national defense information, or NDI, as discussed below and in the classified supplement. No, fear of missing out. No, we can't have that. The wheels on the bus go round and round. They're doing something. It's because Trump would go, yeah, I mean, oh my gosh. All right. The essential premise of the classified supplement is that neither President Trump nor any other party to this action is required to accept the ipse dixit of the special counsel's office or the biased intelligence community regarding the alleged sensitivities associated with the documents and information at issue in this case. The office's own conduct belies these claims. For example, the office has suggested that documents reflecting the timing and content of the president's daily brief on a given day are among the intelligent community's crown jewels. Really? Hold on, everybody. Pause. We're hitting pause for a moment. He would do what I meant to say. Okay. We're hitting pause for a moment. Weren't his daily briefs the ones where they had to draw pictures for him in order for him to understand what was going on because he didn't want too much text? I mean, am I getting that wrong? Wasn't that true? That's okay, thanks, Frank. Yeah, I mean, they drew pictures. This is Florida. This is what a weapon looks like. He never read them. Well, right. I mean, they were... Oh, okay. Moving on. In fact, there are detailed descriptions of PDBs delivered to President Trump on the CIA's public website. Here it says, we're citing CIA.gov, Chapter 9, Getting to Know the President, 4th edition PDF. Yes, and they had to dumb it down for him so he would pay attention. Oh, my goodness. I didn't know that. Yeah, no, it's true. I mean, I think there's there's proof, man. There's, all right. Here we go. I'm sorry, I got distracted. Which are based on the same types of information, including directly attributed quotes from the same witnesses that the office speaks about in hushed tones and seeks to relegate to skiffs. All right. Moreover, as explained in today's separate opposition to the office's SIPA Section 4 motion, prosecutors and witnesses repeatedly ignored the so-called need-to-know requirement during the investigation to share literal war stories that have no relevance to the issues of this case. So is this the point where, in his civil case, where he said, well, all the real estate people do the same thing? Is that what he's saying here? Well, everybody else said top secret stuff. I mean, that's the feeling I'm getting here. My word, the CIA book noted, 334 pages. Nuh-uh. Pence was reading his copy. Oh my goodness. The court should not condone that behavior by permitting the office to invoke the need to know. Yeah, everybody else does it. requirement to withhold discoverable information from the defendants. I think that's important. The need to know is kind of important. All right. Therefore, as discussed in the classified supplement, President Trump will continue to oppose ex parte proceedings under SIPA, which, by the way, ex parte means only one side, and ex parte hearings are a requirement under the code section that sets out SIPA. So I would recommend that they read that. They should test him to see his brain age. Oh my goodness. Oh my goodness. All right, just so everybody knows, the Confidential Information Procedures Act requires ex parte proceedings that serve as a fraught opportunity for the office to push inaccurate and untested narratives about this case, and we will contest in pretrial motions and at trial meritless claims regarding NDI classification status, the significance of portion marks, and other alleged sensitivities. The special counsel's office must make additional disclosures promised long ago regarding these issues and the witnesses they will rely on at trial to try to substantiate their position. Accordingly, for the reasons set forth below, the court should conduct fact-finding on any disputed facts relating to the scope of the prosecution team, enter an order resolving the parties' dispute on that issue, and order the special counsel's office to produce the requested discovery. Are we there yet? Oh my gosh, Jan, it's like you're in my mind. You just totally read my mind. All right, everybody, just a quick side note. So, in case you're interested, the Classified Information Procedures Act is it's a federal act, and it has to do with any time classified information is used in a criminal case. And Section 4 right here has to do with discovery of classified information by defendants, all right? And if you look down here, it says, if the court enters an order granting relief following such an ex parte showing, the entire text of the statement of the United States shall be sealed and preserved in the records of the court to be made available to the appellate court in the event of appeal. So this entire section goes through the requirements that there is an ex parte hearing because it's classified information. All right, so there's the introduction. Oh, yikes. So let's take a look at the government's. Let's take a look at the government's introduction here. My goodness gracious. Oh, my goodness. All right, here we go. Let me just make sure that I am in frame properly here. All right, here we go. Stable genius. Oh my goodness gracious. All right, everybody, here's the introduction for the government side. All right, so you know that this is the government's motion because this was what was filed in February. All right, so here we go. Just making sure I'm in frame here. The defendants have received substantial, timely, and thorough discovery in this case. By early September of 2023, the government had provided the defendants with over 1.28 million pages of unclassified discovery and all the CCTV footage obtained in the investigation. Since then, the government has supplemented its production as necessary. This production not only complies with the government's constitutional and rule-based discovery obligation, it goes far beyond. The government recognizes its discovery obligations, has complied with them, and will continue to do so. The defendants have nevertheless filed a lengthy motion to compel, which I was just reading, everybody. All right, just to make sure we're all on the same page here, in which they seek abstract rulings on the scope of the prosecution team and various directives that the government provide them with a range of additional materials. The motion should be denied as legally and factually flawed. Discovery requests must be based on specific demands tied to the case for items material to preparing the defense. Instead of meeting those standards, the defendant's motion seeks non-discoverable materials based on speculative, unsupported, and false theories of political bias and animus. Many of the requests are so generalized that it's difficult to decipher what they seek. others reflect pure conjecture detached from the facts surrounding this prosecution. For still others, the government has already furnished the defendants with what they seek to the extent the law requires. The government will explain below why the defendant's showings fall short of applicable legal requirements. But before turning to those arguments, it's necessary to set the record straight on the underlying facts that led to this prosecution, because the defendant's motion paints an inaccurate and distorted picture of events. So this is where you can see the government starting to get a little frustrated here. They're starting to get a little bit upset. The government will clear the air on those issues, not because the court needs to resolve factual disputes before denying the motion. It need not resolve the facts, but because the defendant's misstatements, if unanswered, leave a highly misleading impression on a number of matters. After that discussion, the government will turn to the underlying legal principles and their application to defendants' requests, all of which should be denied. A word at the outset about those requests. The defendants have scattered their requests throughout the motion. For the court's convenience, the government includes as an appendix to this response a chart enumerating what the defendants appear to seek. The defendants also have filed a classified supplement in which they ask the court to compel production of various categories of classified information. This opposition responds to the defendants' classified supplement with unclassified arguments to the extent possible. Additional responses are in the government's classified supplement. Okay, so let's take a look, everybody, at the government's chart. Oh my gosh, I can't help it. I've got tears streaming down my face at this point. Let's just flip to their chart. Yes, pictures are important, everybody. So here's our appendix. Oh my gosh. All right, here we go. Before we go back. So here's the request. The appendix, the table of defense requests. So here's the request. So improper coordination with NARA to abuse the grand jury process. And here is A and B. And so they're giving us the pages. So page 36 and page 38. Oh my goodness. All right. Next, the attempt to retroactively terminate President Trump's security clearances. Those can be found on page 36 and 41 and 42. Oh my gosh. The use of secure facilities at President Trump's residences. That's on page 42 here. The attorneys write what they want, or are they writing what Trump wants? Great question. I think it's a mixed bag, in my opinion. I think it's mixed. Evidence of bias and investigative misconduct. And that's on page 47, page 48, page 50, and they're putting the direct lines in. I appreciate that as well. We have a direct quote. So, evidence of bias and investigative misconduct, which is what I'm going to go back through and read through, produce any communications between members of the prosecution team and members, relatives, or associates of President Biden concerning the investigation. So they have a direct quote and page number, and that's helpful. Collecting from NARA and producing documents, so page 51 through 52, page 55. Next, we have production of all correspondence and or communication concerning the search of Mar-a-Lago. Then we have page 56. We have production of CCTV video footage, which is at page 63. And then we have uncategorized area. Prosecution's just cleaning up Trump's lawyer's work. Yes, I think that's exactly correct. I think they're trying to make it so they can understand what's happening here. So we have two uncategorized. One, produce unredacted copies of discovery previously produced to defendants in redacted form. Okay. And produce an unclassified discovery information that was previously produced in classified discovery. What? What even is that? Oh my goodness. All right. So there's the chart, everybody. There's the chart that the government has presented. So let's, it kind of nice since, well, it is nice to have a chart. I'm sure Judge Cannon appreciates that. All right, so let's hop back over then into specifics here now that we've seen the chart. So I want to, there's just too much to go through to go through the whole thing. But I really want to focus on this evidence of bias here because he sets it out and then we have the counter argument in the government's piece. I wonder if they have an attorney for each claim to keep sanity. Good question. Good, excellent question. All right, so let's go here to page 43. She'll give a minute order in 18 days. Oh my gosh, BC, you know it's true. Oh my goodness gracious. Oh my gosh, what's happening? This whole world's gone bonkers. 43. All right, so here we go. We'll go to page 43. So let's dig in just to this evidence of misconduct. There's just too many other issues to hit all of them. Isn't the judge in Florida Doc's case? Well, I'm not sure. I'm not sure if anyone's in anyone's pocket, but we certainly have some questions. There's some questions. I think there's some legitimate questions. All right, here we go, everybody. So let's start with evidence of bias in investigative misconduct. So we'll read a few pages here and then I'll flip over to the government's counter argument. President Trump, so that's how you know that it's his motion, all right, and that it was filed in January, is entitled to disclosures regarding the issues set forth below, which support his defense relating to the politically motivated and biased nature of the investigation that led to the pending charges. All right. Okay. Oops. Hold on, everybody. That was page 43. I'm flipped around here. So we have page 43, and then here's 44. The requested materials are discoverable because they support pretrial motions under the Sixth Amendment, due process principles, and other constitutional limitations on governmental conduct during a criminal investigation. All right, and we're citing a case law here. Outrageous government conduct occurs when law enforcement obtains a conviction for conduct beyond the defendant's predisposition by employing methods that fail to comport with due process guarantees. All right. Citing more case law describing potential due process problem where two government arms collude in bad faith to deprive the defendant of his constitutional rights. You know, I don't think these cases are about that, but okay. The materials are also subject to the Brady obligation of the special counsel's office because the requested information that can be used to attack the reliability of the investigation and argue that it was shoddy. Here, I feel I would read this, but I'm worried that this is misstating the law, so I'm going to kind of skip through these quotes because I've not read these cases, so I'm not sure that they're actually quoting it correctly. Attacking the politically motivated nature of a case is one permissible form of impeachment at trial. So impeachment, everybody, at trial is basically what we call cross-examining a witness or pulling up information to ask a witness who's testifying at trial. So, I mean, are we at trial right now? I don't know what you're talking about there, but interesting. All right, here we go, flipping. Again, I cannot rely that these quotes are correct out of these cases, so I will skip through them. For example, President Biden's unprecedented and politically motivated abuse of President Trump's executive privilege in response to inquiries from the J6 committee and in the subsequent purported delegation of the decision to NARA as reflected in the May 10th letter is central to these issues. What? What? Okay, wait. President Biden's unprecedented and politically motivated abuse of President Trump's executive privilege? What? What does that mean? Wait, I'm confused. Wait, all right, hold on, everybody. Let's do a visual. President Trump, unprecedented and politically motivated abuse. So he abused something. He abused President Trump's executive privilege. How can Trump have executive privilege when Biden's president? That's a great question. So he abused his executive privilege in response to inquiries from the J6 committee. So President Biden responded to the J6 committee using President Trump's executive privilege, and in the subsequent purported delegation of that decision to NARA, as reflected in the May 10 letter. Does anybody know what that means? I think he's referring to Biden revoking Trump's privilege to have access to information after leaving office. Okay. So, abuse of President Trump's executive privilege. So, his executive privilege, yeah, it's not English. So, his executive privilege is over when he leaves office. That's the end of executive privilege. That's it. Like, immunity is also over at that point as well. No, he cannot use someone else's executive privilege. Biden didn't revoke it. The government did. Well, I think once you're not president anymore, you don't have executive privilege. I think it's like at midnight, whatever. It's like a Cinderella turning back to a pumpkin situation. It wasn't Biden, it's how the government works. Is he trying to say J6 was in the function of office, so it has privilege? In response to inquiries here. Okay. So, I'm not sure. You lose your oh my goodness. I'm not sure what this means, everybody. I'm really not sure. I'm not sure. I'm going to have to chew on that a little bit further. But let's look at this case, Trump v. Thompson, which is a U.S. Supreme Court case. And it was one of the cases I went through before. So let's take a look. A former president must be able to successfully invoke the presidential communications privilege for communications that occurred during his presidency, even if the current president does not support the privilege claim. Concluding otherwise would eviscerate the executive privilege for presidential communications. So that's a misstatement of this case. Actually, this is wrong. So I'm gonna have to let this whole paragraph go as incorrect. He's trying to claim executive privilege because he was working towards. Okay, the current president doesn't govern that at all. Makes no sense. Don't feel bad. Logically, it makes no sense. Darn the logic. He's saying the privilege, right, should not be used against him. Right. So, yeah, I think what he's trying to state, because in the Trump-Thompson case, we had a couple of cases that came up saying he didn't want to have to comply with certain subpoenas and information that Congress was requesting. And in those cases, first, the case in Georgia, they're saying if a state is investigating, that's not up to you, or New York, that's not up to you to decide. Congress and states need to be separate. And then also, you have to comply with congressional subpoenas so long as the reason that they're asking for it is reasonable. Just read Nixon 2 says what they just said. I have no ideas. I don't know, everybody. We're going to have to skip past that one because that's weird. I don't think he understands it as temporary. I agree. All right. Let's keep moving on. Let's keep on trucking here. Number 1, special counsel coordination with the Biden administration. All right, let's see. Communications with the prosecution team members regarding the underlying investigation by members, relatives, or associates of the Biden administration are discoverable because they support President Trump's defense regarding the politically motivated nature of the prosecution. How is this support? That is not a legal argument. here. Again, we need to skip this because I think it's a misstatement. If he gets a judge to side with him, he can use it in another court. Well, I mean, this is the Supreme Court. In April of 2022, the New York Times reported that as recently as late last year, Mr. Biden confided in his inner circle that he believed former President Trump was a threat to democracy. And should be prosecuted, according to two people familiar with his comments. Okay. That article also indicated that Biden had said privately that he wanted the Attorney General to act less like a ponderous judge and more like a prosecutor who's willing to take decisive action. What does any of this even mean, everybody? Is this even relevant? Okay, I'm objecting to relevance. I'm objecting. Biden said that on TV. Yeah, I mean, but how is that relevant? So they're saying because he said this, then that there's political bias. But then, I mean, so anything that you say can show that you have political bias? Is that what we're saying? Because that might be a tough road for Mr. Trump to walk down. Oh my God, is this real? Good question. Is anything they do relevant? Good question. All valid points, everyone. All valid points. Oh my gosh. Oh my gosh. He wasn't immune. I don't think anybody did. Explain. Okay. All right. Keep moving on. November 9th of 2022, Biden was much less private. All right. So he made some statements about Mr. Trump that was negative. And that means that he is biased and is weaponizing something. That's ridiculous. What about the First Amendment? What about the First Amendment rights? Doesn't he have First Amendment rights? When will this nightmare end? Excellent question. On November 9th, all right, Biden was much less private. At a press conference, he stated, quote, "We just have to demonstrate that he will not take power if he does run. I'm making sure he, under legitimate efforts of the Constitution, does not become the next president again," end quote. And then footnote 19, remarks by President Biden at a press conference, the White House here, the White House briefing room, okay? On November 15th, President Trump announced that he would run for a second term as president. On November 18th, Biden's Justice Department appointed Jack Smith to oversee this case. I still don't see the relevance. I know the First Amendment. We need to attach aspirin with every motion. Oh my goodness gracious. Oh, then Trump is severely biased. Yeah, that's what I'm saying. If all the stuff that Trump said, that wouldn't even work. We would all be in prison. Anyone that ever looked at him cross-eyed would be in prison. Or normal-eyed. It doesn't even matter. The sequence of events supports Trump's defense that the charges against him are politically motivated. So let's just make sure we're hashing this out. He made some comment allegedly, which has not been confirmed, to the New York Times, and then said it's something else at a press conference saying that we need to make legitimate efforts of the Constitution. So these two statements, one is completely unsubstantiated, are showing then that his prosecution is politically motivated. Never make eye contact. Oh my God, that's so funny. Jackson CC'd the president on emails. Well, did he? I mean, come on, right? I mean, what? He knew he was being investigated. It wasn't a big secret. Yeah, I agree. He keeps calling it President Biden's DOJ. They obviously don't know how it works. I agree with that too. He's simply trying to claim directed investigation. All right. That's not circular in terms of politics. It doesn't seem like that would be enough at this point. I mean, to say that a prosecution at this level would be. And another thing, here's another side note, everybody, while I'm on this, all right? So, all right, let's just say Biden was like, "Oh, Jack Smith, go get, Mr. Trump. Boo-hoo, I don't like him." Let's just say that. But did Biden put the classified documents in Trump's bathroom? I don't think he did. Or the ballroom. I mean, I don't think President Biden moved classified nuclear and military documents into Mar-a-Lago and then scattered them about. I just don't think he did that. Right. Right. I just don't think. Right. I mean, so it's politically motivated, but like you had classified documents in your house. Like, I mean, I don't get it. I don't get it. Wasn't he the DOJ that started? Right. Well, it was NARA. It was NARA because NARA was like, dude, we're missing some documents. Can we look through your stuff? And he's like, no. And they're like, gosh darn it. Fine, we'll get a warrant. Did Biden have a grand jury selection from his Gosh, that's a great point. Was the grand jury made up of all of Biden's relatives? I mean, and like one of them took their mask off and it was Hunter and he was holding his laptop. Oh my goodness gracious, everybody, come on. Are we in Scooby-Doo land? Is that what's happened here? Dude, we're missing documents. Seriously, where are our documents, man? Give us the documents. And he's like, I'm not going to give you anything. And so they're like, fine, we got to get a warrant. Look at all this stuff now. Look what you did to yourself, man. All right. I digress, but you know what I'm saying, right? Those pesky kids. Well, yeah, I mean, come on. It's politically motivated. Again, I mean, there were boxes inside of your bathroom. I mean, come on. So choices, yeah, exactly. So let's just, just to be clear, I don't think Biden put the boxes of the stuff in your room, dude. I think you had the people pack up the boxes and put the boxes in your room or in the bathroom. I mean, come on. Like this isn't Biden doing this stuff right here. That's not Biden stuff. He can't lift that. He's a little old man. He's not doing that. Oh my gosh. It's a bad episode of Twilight Zone. I know. I know. He even hit the boxes and asked the IT guy to delete the footage. I know, right, Adrian? I know. Oh my gosh. Biden's never been to Mar-a-Lago? Well, yeah. I mean, come on. I'll never get sorry about the bathroom picture, everybody. I'm just trying to prove a point here. I'm just saying, you know what? I don't care how politically motivated you are. Somebody in Mr. Trump's world put these boxes in these places, and there were nuclear codes in there. Oh, my gosh. You can't tell me that's politically motivated. All right. Enough with the pictures. Put them in the bathroom because it was burning. Oh, my goodness. All right. I'm sorry. I digress. Here we go. Let's make it through because we want to see the government's argument. Mean Joe Biden. Joe Biden is so mean. All right. The sequence of events supports Trump's defense that the charges against him are politically motivated. Many of the actions by the special counsel's office, and in particular their efforts to rush to trial based on misrepresentations about discovery and an unprecedented schedule in this case, and the D.C. case on behalf of the Biden administration. What's the D.C. case is on pause, man? Fly in the face of the Justice Manual. Are we quoting the Justice Manual? Oh my goodness. With a copier nearby. Oh, good point. Good point. He didn't want to take a lunch break when the lawyers came to talk to him. Thought President Biden was sleeping, not Ninja Warrior. Oh my gosh. Oh my gosh. He's won New Hampshire 3 times. Woohoo. Oh my gosh. This provision was promulgated in August of 2022, just months before Jack Smith was put into place, and it provides, oh my gosh. Federal prosecutors and agents may never select the timing of any action, including investigative steps, criminal charges, or statements for the purpose of affecting any election or for the purpose of giving an advantage or disadvantage to any candidate or political party. I can't even read it. Because I don't trust it. I don't trust that this is actually a legitimate quote out of what they're saying this is. Because this is just not, I can't trust it. They're saying this is the Justice Manual, but I don't know that it is. So we'll move on. Oh my goodness. goodness gracious. All right, so the conduct of this office in this case plainly violates this section of the Justice Manual, allegedly, and would under normal circumstances be inconsistent with the department's mission, but these are not normal circumstances. President Biden has all but admitted that through leaks to the New York Times in his November 2022 press statement, and the Attorney General has acknowledged that he personally authorized his investigation and approved the raid on Mar-a-Lago. I'm wondering if they're getting mixed up with like defamation statements. Like, you know how in the Carroll case, each one of his statements is defamation. And so here they're saying, well, Biden made this statement, and then he most likely made this other statement. And so they're trying to use those statements like they would in a defamation case. Keep it, I'm still stuck on the Justice Manual. Yeah, I'm unfamiliar with the Justice Manual. I'm going to have to look it up. I'm going to have to look that manual up. I'm going to have to take a peek. All right. I think they're mistaking what those statements can be used for, but whatever. Given these circumstances, any communications between members of the prosecution team and members, relatives, and associates of President Biden concerning the investigation are discoverable because they support President Trump's defense that his prosecution is improper and politically motivated. So this is just a conclusory sentence. This isn't actually giving any kind of support. Like there isn't even a case law that would support anything. There's no support. They're just saying, well, we think he did this, and so you should give us all of this extra information. Wouldn't his lawyers know differently? Yeah. So many candles burning. Yeah, the special counsel's office must review the electronic communications of all prosecution teams and produce any such documents. So, what are they even talking about? All right. Let's go to the government's response. So, we've only made it through a couple, but this is getting ridiculous. So, let's take a look at the government's response to the bias here. What point are these motions just gross incompetence? I think we've already passed that. We've passed the point of incompetence. Yes. Actions that may impact an election. What logic would we need? I know. What's the prosecution teams? Yeah, so let's go back for a second then. What they're saying here is they're saying the special counsel's office must review the electronic communications of all prosecution team members and produce any such documents. So anyone involved in the prosecution, they're saying all of their electronic communications should be reviewed to see if there was anything in there that could support their claim. So they're asking them to investigate their own people to find support for this conclusion that they have with no evidence or information to back it up with. It's in the manual. That's right. It's in the manual. That's the guidance saying that, yeah, too close to the election. Yeah. Canon's not going to let it. I don't know what's going to happen with Canon. I don't know, everybody. I don't know. All right. Here we go. Let's take a look here. Let's get into how the government responds back. Okay. So let's go into page 30. Doesn't specify a time frame. Yeah, I mean that's an excellent point. Just forever, you always have to. From the beginning of time, all communications, electronic communications from the beginning of time. All right, let's take a look at the government. Now again, we're in the government's motion, their response, because we're in February here. Can you imagine some of the memes in those emails? I can't. I can't. Oh my gosh. This is just wacky land. We're in wackadoo land. All right, here we go. We're in the government's response. All right. So discussion. Applying these principles to the defendant's discovery request shows that their motion to compel should be denied in full. The defendants group their requests into 6 main categories in which they seek evidence of improper coordination with NARA to abuse the grand jury process, evidence relating to the attempt to retroactively terminate President Trump's security clearance and related disclosures, evidence relating to the use of secure facilities at President Trump's residencies, evidence of bias and investigative misconduct, which is what we just read through, a piece of it, all correspondence and or communication concerning the search of Mar-a-Lago, and CCTV footage. These also include 2 additional uncategorized requests seeking the removal of redactions and the production in unclassified discovery of certain materials produced in classified discovery. Each request, to the extent that it seeks evidence that has not already been turned over, fails to establish one or more of the requirements for a motion to compel, namely that the evidence sought must be material to the defense, must be within the government's possession, custody, or control, and must not be protected from disclosure by an applicable privilege. All right, so let's see what we've got. All right, let's go into the first piece. The court should deny defendant's request for evidence of improper coordination with NARA and bias and investigative misconduct. 2 of the categories of information sought in the motion to compel can be considered and rejected in tandem. Specifically, the request for evidence purportedly showing improper coordination with NARA to abuse the grand jury process and evidence of purported bias and investigative misconduct are both grounded in a request for information that is neither material to the defense for the purposes of Rule 16 nor material to guilt or punishment for the purposes of Brady and should therefore be denied in toto. All right, let's look up these 2 footnotes here. We've got footnote number 14 and 15. 14. Within this category, the defendant specifically requests all reports, notes, and communications concerning the production of documents by NARA to DOJ, FBI, or the Special Counsel's Office, and the decision to issue grand jury subpoenas to NARA during the course of those events. And B, the 81 documents referenced in Exhibits 57 and 58, as well as a subset of 19 documents already in DOJ FBI possession and the 1581 flagged for use here. So that's number 14 and number 15. Within this category, the defendant specifically requests a communications with the prosecutor team members regarding the underlying investigation by members, relatives, or associates with the Biden administration. That's absolutely ridiculous. B, communications between the Biden administration and prosecutors in Georgia regarding any of the pending prosecutions of President Trump. C, classified materials and supporting documentation relating to the January 6th submission to the Senate Select Committee on the Intelligence by the Intelligence Committee Analytic Ombudsman, Dr. Barry Zuloff. And D, documents and communications with NARA relating to 9 listed topics. E, documents and communications reflecting bias and or political animus towards President Trump by members of the prosecution team. And F, additional communications concerning Mr. Woodward, including communications about Mr. Woodward's August 24th interaction with Mr. Bratt. So he's asking for any kind of communication from the prosecution team about Mr. Trump. Yikes. Moreover, many of the specific requests within these 2 categories seeks evidence from agencies including NARA, the White House, and the intelligence community that are not part of the prosecution. I still think he made copies of documents and that he had long enough. Yeah, it's a good point. Not part of the prosecution team. And any items that may in fact be within the possession, custody, or control of the government are privileged and not subject to disclosure. To be clear, the defendant's requests are predicated on a false narrative. The investigation and prosecution of this case have been appropriately driven by the facts and the law, not by any form of political bias. But the question at this juncture is whether the defendants have met the legal standard to compel discovery in support of these false claims. As explained below, they have not. So let me skip forward, everybody, because I want to kind of go direct to what we read out of Mr. Trump's motion here. So let's see. make sure. Let's skip to number 2. Okay, here we go. Some of these requests seek evidence that does not exist or is not within the government's possession, custody, or control. I want copies of any copies that you've made each. Like, good point. I'll be stuffing envelopes full of fine glitter. Oh my goodness. Oh my goodness. All right, let's take a look here. Some of the requests within these 2 categories independently fail for separate reasons, since they seek evidence that either does not exist or is not within the government's possession, custody, or control. Communication between the prosecution team and members, relatives, or associates of the Biden administration. The defendants seek the disclosure of communications with prosecution team members regarding the underlying investigation by members, relatives, or associates of the Biden administration. The defendants make no effort to define the term Biden administration. To the extent the term refers to president, the vice president, and senior White House political officials, no communications between prosecutors and those individuals or their family members exists, let alone communications about the investigation. To the extent that the defendants request information from specific components within the executive branch, that contention is addressed below. So let's take a look at NARA. The government has produced to the defendants all discoverable material from NARA within its possession. The defendants nevertheless ask the government to collect from NARA and produce documents and communications relating to 9 specific topics. The defendants also seek to compel the disclosure of all reports, notes, and communications concerning the production of documents by NARA to DOJ, FBI, or the Special Counsel's Office, and the decision to issue grand jury subpoenas to NARA during the course of those events. While not entirely clear, it appears the defendants are referring to reports, notes, and communications within NARA's possession, since the government has already produced non-privileged reports, notes, and communications within the possession of the Special Counsel's Office or the FBI. These requests should be denied for the reasons discussed above, but also because NARA is not part of the prosecution team. The prosecutors do not and did not exert authority over NARA. NARA does not work under the direction or supervision of prosecutors, and NARA does not and did not function as an agent of prosecutors. In January of 2022, NARA collected and reviewed 15 boxes from Trump before any criminal referral had occurred in furtherance of its core function, which is to serve as the nation's record keeper. Once NARA made criminal referral in February of 2022, it did not pool its investigative energies or undertake a joint investigation with prosecutors. Instead, DOJ commenced a separate criminal investigation, and NARA's involvement in the investigation consisted entirely of providing documents and information. For some requests, NARA provided the documents voluntarily. When the government sought PRA records, Presidential Records Act records, however, NARA required a grand jury subpoena consistent with the regulations under the Presidential Records Act. No NARA personnel participated in interviews other than as witnesses, presented the case to the grand jury, accompanied prosecutors to any court proceedings, or played any role in the development of prosecutorial strategy. And then we have a footnote 20 here. The government's acknowledgement in U.S. v. Trump that NARA's Office of the Inspector General participated in the investigation in that case does not mean that NARA is part of the prosecution team. NARA OIG's involvement in the election case included participating in witness interviews and individuals outside NARA and coordinating those activities with the FBI, functioning essentially as an investigating agent. None of that occurred here. In other words, NARA OIG, which is authorized to conduct investigations and make criminal referrals, participated in joint investigative activity and pooled investigative resources with prosecutors and investigators on the election case. That is entirely distinct from the archival and administrative staff at NARA providing information consistent with its status as a victim agency in this case. Wow. All right. So they're setting out here that NARA was completely independent and distinct. So let's go, okay, let's hit this last piece here. So the defendant's request for internal communications by members of the prosecution team seeks items not subject to disclosure. So let's go into their final point. Finally, to the extent any request seeks material information within the government's custody and control that takes the form of an internal communication within the Department of Justice or the Special Counsel's Office, such information is privileged from disclosure. With respect to the Department of Justice generally, the defendants suggest that they are entitled to internal correspondence and other materials from senior department officials about the August 2022 search and other key decisions during the investigation. Putting aside the defendant's failure to cite a single case to support their broad assertion that high-level officials within the Department of Justice function as a part of the prosecution team, any internal discussions about prosecutorial strategy or key decisions fall well within the ambit of the work product and deliberative process privileges. So it's all protected. Rule 16 clearly forecloses the defendants' access to any reports, memoranda, or other internal government documents made by an attorney for the government or other government agent in connection with investigating or prosecuting the case. Just as the internal communications of a U.S. attorney are not discoverable, even if he or she, for example, reviewed and approved a warrant application. The defendants here are not entitled to internal communications of DOJ officials. So there we have it. Yeah, it would be a lot. It would be a lot. So let's take a look. That's, I think, kind of summarizes what we had been going through. But let's take a look and review our chart again, everybody. You tell them. No. Oh my gosh. Let's take a look at our chart one more time. Oh, thanks, Kristen. Yes, this is another Etsy pen from a lovely shop. I will have to remember to get the name of the shop next time. But so we've got the appendix here, the table of the defense requests. So these are what the defense is requesting, and they put out each page where they are making these requests. And then the government went through and said, hey, look, you're not entitled to that information. And visual aid is important. It really is. It really is. Well, let me get the calendar out then, everybody, so we can take a look at what's coming up here on our chart. So here we go. We've got February set. Those motions are fascinating, everyone. It takes a lot, though, to get through them. Winner, winner, chicken dinner. They asked knowing that they couldn't get them. So they said, well, yeah. I mean, I think it's just a lot. Ask for all the Trump lawyers. Yeah, for their internal communications. Exactly. It's work product and it's privilege. You can't just ask the Department of Justice, hey, can you give me anything you ever said about me at all, ever? Like, what are you talking about? All right, everybody. So we've got a lot of things going on this week when it comes to the Supreme Court. We've got several things due. The response to Trump, if a response is allowable, is due for the Supreme Court case for Colorado. So we might see a few more filings out of the Supreme Court docket tomorrow. We also have pretrial motions that are not motions in limine due in the Georgia case. So that is set for tomorrow. We've got the Nevada primary and Nevada caucuses this week. We'll see how that turns out. And then on the 8th, everybody, we've got the big oral arguments for the SCOTUS case. So this is the Colorado presidential immunity case that is set to be heard by the U.S. Supreme Court on the 8th. So this week, I will probably be taking some time to go through and summarize the amicus briefs that have been filed for SCOTUS. I did spend a lot of last week going through the 14th Amendment, the historical cases, as well as the current cases that are going. So I may spend a little bit of time going through the amicus briefs on that this week. But we will see, because we should have some pretrial motions set out in Georgia. So once those motions get filed, I will go into those as well. And then the following week, everyone, we're getting into that SIPA Section 4 hearing in Florida. So that's the big hearing for Florida. Quality time, absolutely, absolutely. So I do plan to probably to follow the same schedule I did last week. It seemed to work out really well for me to do a Monday, Wednesday, Friday. That worked out nicely for my my voice. I got to be careful I don't overdo my voice, but I will be doing a special live on the SCOTUS oral arguments on Thursday. So I'm not sure exactly how I'm going to work that, but I will do something regarding that. But I do plan to be here Monday and Wednesday and Friday, and then I will do a special live regarding the SCOTUS arguments on Thursday then. So that should be really interesting. We should have some interesting motions filed here. Now, Judge Engeron has said there's some talk that Judge Engeron's decision may be coming out tomorrow, but there's also some talk that it may not be out until the 9th or even the 12th. So we're not really sure exactly when Judge Engeron's decision comes out, but as soon as his decision is filed, I will be going live and going through that decision as well. We're also waiting on the DC Court of Appeals case, everybody. So we've got the immunity case. I think I had flipped that around when I first started talking about this. So Colorado is whether or not he can be on the ballot in Colorado, but the DC Circuit case has to do with presidential immunity. We're still waiting on that answer. So we will, as soon as that comes out, I will be going as well. Now, I do like to do a few pop-up lives. If interesting things come out and new information comes out, I do like to come on and try to explain things as best as I can. So as soon as the answer becomes public, yes, exactly. So I will be coming on if we have any kind of super important filings. I will come back on, but my normal scheduled time where I will have comments on for everybody will be Monday, Wednesday, and Friday this week, and I will be doing a special live on Thursday. I'm not sure what format yet I will be doing. So that's what this week is looking like, everybody. We're almost at 100K. Oh, yeah. Well, thank you. Yes. Get your live alerts like one of those phone TV alerts. Yes. Well, I'm glad. I have several things I still have on my own docket to cover, but I'm trying to keep up with everything that's been going on. There's a lot. There's a lot going on right now, everybody. How are my tachos? Oh, they were good. They were very tasty. They were tasty treats. Should send email alerts. Yes, that's right, VC. So if you sign up with the New York court system, when you go in, you can get emails for that. And, you can get emails for a lot of our different court systems too, if you're looking into different courts. One more thing I wanted to ask was, we do have the Crumley case, right? That's kind of been going on right now. And I have a ruling that came out from the appellate court regarding whether or not the case could even be heard. Now, of course, we know the case is being heard, but it gives a synopsis of what she was charged with, what both of them were charged with, and the circumstances allowing for the trial. Now, I'm just wondering if this is something that people are interested in. So this is the state of Michigan, the Court of Appeals. They had to get special permission to even go forward on her case. So this is the case where she and her husband have been charged with what has happened because of their son's actions. So I think it's important. This is really the first case of its kind where the parents are being pulled in as well. I thought I would go through this opinion that was given by the Court of Appeals in Michigan. Okay, yes. So, defense attorney, yeah, oh my gosh, everybody, yikes. Yikes, yeah, it's pretty rough. Okay, so what I will do then, I watched your full trial, okay, excellent. So what I will do then is I probably will do this tomorrow night, everybody. I'll probably make this a Monday night That's a good one. Yes, I think it's very important. Very important. So I will go through and kind of annotate this out to pull out the big pieces that I think are the most important so we can kind of talk about what's happened with her trials. So I will go ahead and do this. We'll do this one tomorrow night then. Felt she was a witness, was very credible. Yeah, I know her cross-examination has been made available online, so you can take a look at that. But I think for me, I look at it from the perspective of this being a case where the parents are pulled in. We've had cases where parents have been sued before and it's been dismissed because one reason or another. And so to actually have a criminal case going forward is absolutely fascinating here. So, oh, thank you, everybody. Oh, thank you for all of the likes. I certainly appreciate it. So I will go ahead and we will go through the Crumley case tomorrow, then the Court of Appeals decision, and kind of touch on those issues. But it should be a pretty interesting week, everybody. So with that, my friends, I will sign off for tonight. Thank you as always to my moderators. I hope you were able to have a nice little break for tonight. I do my sub chats only on Sundays. The rest of the week, I do turn on comments so everyone can join in. But I do like to do one a night a week as just a huge thank you for the support. And I'm so thankful for everyone's support. So I'll go ahead and sign off for tonight. Good night, everybody. Thank you for coming by and hanging out with me. This was a very fun, fun chat that we had with our dueling motions. I will be back again tomorrow night, 7 o'clock Central, and I will be taking everybody through the Crumley case. So that should be an interesting one. So I will see you all tomorrow. Have a great rest of your night, everyone, and take care.